You can't be too sure that somebody is going to make things right unless you have a lawyer.
If you're a construction worker who gets hurt on the job, what are your options to get help? We are going to find out on this episode of Ask the Lawyers. Hi, everybody. I'm Judy Maggio with AskTheLawyers.com, and my guest today is New York attorney Jeff Antin, who has been helping injured New Yorkers for nearly 30 years. We do have a quick reminder before we do get started, though, and that is if you want to ask Jeff specific questions about your situation, simply go to AskTheLawyers.com, click on the top of the page that Ask the Lawyers button, and it will walk you through what you need to do to ask Jeff a question. So, Jeff, if a worker is injured on a job site, I'm wondering, is this a personal injury issue or a workers' compensation issue? Explain the difference there, how you know.
Okay, so here's the deal. Anybody who's injured on a work site has a workers' compensation claim, okay? A workers' compensation claim, you don't have to prove that anybody did anything wrong. The fact of the matter is, if you're hurt on the job, doesn't have to be through anybody's negligence. You could have tripped over your own 2 feet, you automatically have a workers' compensation case, okay? If you're on a construction site and you work for a subcontractor and you fall from a ladder, for argument's sake, you can bring a case against the owner of the property, assuming it's not a 1, 2, or 3 family, house, and the general contractor. Okay, so and depending upon how it happened, I mean, there are statutes that make that make the owner and or general contractor absolutely liable for what happened.
What is the general contractor's responsibility, though, if a subcontractor is injured on a job site? Do they have to, say, prove fault by another worker?
Basically, what the cases have come down and said, if you get injured as a result of the force of gravity, is really what the cases say now, then generally speaking, you more than likely have a case against the general contractor and the owner of the property. Pursuant to the law under those statutes for failing to provide proper and adequate equipment that would have prevented the accident from happening.
Do you think a worker should trust their employer or the general contractor to take care of them if there is an injury claim?
Listen, you obviously have adverse interest to your employer and the general contractor. If you get hurt, on the job. In other words, both are going to try to minimize either the extent of your injury or how it happened. I mean, obviously, they're going to want to minimize what happened or how it happened, or make you, the sole, make it appear as if you being the worker, that your actions were the sole proximate cause of the accident. In other words, that nobody else did anything wrong but you, and if you didn't do X, Y, and Z, then you wouldn't have been injured. Now, it's not easy, I don't think, to do that, but in any event, everybody's interests are going to be adverse to you.
I'm curious about workers who are members of unions. Do they provide the attorney, or do you choose your own? How does that work?
No, they don't hire the attorney for the worker. The worker has an absolute right to hire any lawyer that they choose. Now, for some reason or another, some unions, do put pressure on the worker to hire a certain lawyer. And to be honest with you, I don't really understand why that is the case, or what power they have over the worker, for them to choose the lawyer that the union suggests. But I've been in situations where I've had clients who were originally, or who were represented by attorneys that the unions, I wouldn't say provided, but the unions introduced them to, that wanted to change lawyers, and come to me for argument's sake, and they encountered problems with the union in terms of not wanting these individuals to switch lawyers. In one case, the individual was in a union and his brother was also in the same union. And while this person was hurt really badly and was very unlikely ever to go back to work, his brother was still working in the union. And the union said to this person that if you change lawyers, your brother will never work again, or something like that. Or we won't find work for him again. And obviously in that situation, I mean, he wasn't going to change lawyers. So I don't understand what's in it for the union. I don't really get it, but that's unfortunately a reality. So.
Final question. Why do you think an injured worker should talk to an attorney or hire one, knowing that attorneys take fees out of the actual claim?
If an injured person doesn't have an attorney, he's not going to know what can hurt him if he were to answer questions about an incident. It's not necessarily about them saying that the accident didn't happen or anything like that. It's just about the fact that any type of statement, any kind of deposition, the other side is only going to use the part that helps them. They're never going to use the part that helps you, that helps the worker, that is. So the point is, generally speaking, nothing the worker can say if he's not represented by an attorney is going to help them. Only because whoever he's speaking to is only going to look for the holes in his story and hang on to that.
So much great information today, Jeff. Thank you for answering our questions. That will do it for this episode of Ask the Lawyer. Our guest has been New York attorney Jeff Antin. Quick reminder, if you have a specific question for Jeff, just go to AskTheLawyers.com. Click the button at the top of the page that says Ask the Lawyers, and it will walk you through that process. Thanks so much for watching. I'm Judy Maggio with Ask the Lawyer.